Good morning, Your Honors. May it please the Court, Paul Lynn for the Commonwealth. Simply put, a straightforward reading of the statute and case law cannot support the suggestion that a recording made with a device known to record audio and held in plain view is secret. Those are the words of the First Circuit.
But isn't that inconsistent with the testimony in this case, that in fact the defendant had no idea that he was being recorded, that it was secret, because otherwise it would be ineffective police work?
The police absolutely admitted that this was a recording that they wanted to be secret, and I do not doubt the defendant's assertion that he was unaware of it.
Okay.
But it is past time to retire the phrase actual knowledge in connection with the wiretap statute. Recent case law, Glick, Ashley, Morris, and especially Rivera make it clear that the standard is whether there are objective circumstances that put the defendant on notice that it might be recorded.
That's overstating it a little bit, because first, Glick is a federal case, and in that case, while the arrest of the other individual was going on, Mr. Glick is standing there with his camera out, facing the police, and at one point, they say something to him like, "Stop taking pictures," and he says, "I'm recording." So that's different than where, again, I haven't seen the videos just yet, but taking the testimony at the hearing, where, to his credit, the officer said, yeah, it would be really a bad police work if he knew we were recording him. Your proposition that we should now take the view that just because all of these phones have recording capabilities, it means that the wiretap statute really doesn't mean anything anymore.
That is a sad fact, more than the Commonwealth's position. It is true that virtually everything we do and say these days is recorded.
But with the ubiquity of cell phones, if I'm at Starbucks with one of my friends and the person has a cell phone on the table, I don't think that they're recording me. I just don't get your point. Right. That everyone has a cell phone out. It's hard to see someone not with the cell phone out, and you don't think that people are press and record on the sly.
Particularly with all of the other capabilities that phones have.
True, which the Glick court held was irrelevant where the phone was in plain view. I don't think it is a bad distinction that the Mass Association of Criminal Defense Lawyers makes, and if I may use my phone, it's off as a prop here. Between.
How do we know that?
Because it is a reasonable difference to say there's a difference between this and this and this. Right. Which you could use in this case to distinguish this case from the other cases. But nonetheless, the Commonwealth does not have to prove actual knowledge. It just has to prove that there is objective notice that the recorded party's behavior is being memorialized in some way. And in Glick, the officer made it clear that he did not realize he was being audio recorded, because he says, "No more pictures." And when the defendant responds, "I'm audio taping you," that's when he's arrested. So it's clear that the officer did not have actual knowledge that he was being audio recorded. But as you pointed out, Your Honor, Justice Jordan, there was clearly an objective knowledge that he was being memorialized in some way.
But I'm still confused. Even if we modify the rule as you would like, where does that get you here? Because he's clearly not putting the phone out like this.
No, clearly not.
So where does that get you?
It gets you a phone in plain view.
Any phone, just back to Justice Gaziano's view, anytime somebody's put their phone out anywhere, that's your rule. That's the new rule you want us to adopt, that then you know you're being recorded. You don't really want us to write that, do you?
No, I think that was too broad. But I mean, here he's got the phone out. He's not hiding it.
Modify it for us. The rule you want is what?
That, when a person has a phone out in plain view, I mean, and I will say that the video, the videos in this case show that he's holding it in his hand. I mean, you never see his hand, but it's clear from the way the footage moves that he's holding it. Sometimes he changes the direction of it.
But counsel, we have no factual findings of this kind below because the Commonwealth did not argue secrecy below, correct?
Correct. But
So can you please make an argument as to why we should even reach this issue on this record?
as I say in my reply brief, I have three reasons. The first reason is because we need guidance on this issue in light of Glick and Rivera. The second reason is because we don't dispute any of the findings that the judge made. As you pointed out, that the officer candidly admitted that that the police intended for the recording to remain secret. He said the phone wouldn't necessarily be hidden. We all agree with that. And as for the video recordings, those are reviewed de novo. So the fact that the judge was not able to make findings regarding the video is completely irrelevant because this court
The point, I think, is not the ability to make the finding, it's the failure of the Commonwealth to make the argument.
Oh, we certainly did not make that argument.
Okay.
By the time I got that case, that opportunity has passed.
And if we reach the argument here, as you want us to, it would be to reverse the judgment of the trial court.
Correct.
And in what legal proposition do you have for that? That we should look de novo at evidence to address an argument that was never marshaled in order to reverse the trial court?
I don't have a case off the top of my head for that.
Usually, we
proposition.
don't do that, in
Yes,
fact.
but as again, where there's no, you would not be rejecting the judge's findings back
Isn't
here.
Alphys and those whole line of cases say we can't do that? That we can't decide a case we can't do just what Justice Wendland said. There's a whole line of cases say that that's not permissible. Not only are there no cases saying it is permissible, we got a whole line of cases say it's not permissible.
I can't think of a case that
So let's
says
just
that.
assume we're going to follow the law.
Yeah.
Can you address why the video is not suppressible as contents of an audio recording?
Yes, because there's absent the audio recording, there is no evidence whatsoever of any communication that was intercepted.
Does it show the identity of the parties?
It certainly shows the identity of the parties, but it would have shown the identity of the parties even if it had
I
been
meant,
silent.
by it, I mean the video shows the identity of the parties,
Yes,
right?
definitely shows it shows the identity of the defendant.
Right, so if we do the math and we go to suppression of evidence, because we're not talking about constitutional suppression, we're talking about statutory
We're
suppression.
definitely talking about the wiretap statute.
So under,
It wasn't.
under 99 section P, it says any person, i.e. the defendant, may move to suppress the contents, right? And then it defines contents in 99B5 as contents when used in respect to this means any information concerning the identity of the parties.
But without any evidence of an intercepted communication, there's no evidence to the parties of an intercepted communication. The defendant here was arrested after the third buy. This isn't a case.
But the
as
video shows that at least the defendant is speaking.
It shows that he's moving his lips, so we can infer he's speaking. But again, a silent video would do exactly the same thing. If the Commonwealth would go out tomorrow.
But this is an integrated audio and visual recording.
Absolutely true. There's no question about that.
Yeah, I don't know about.
But it doesn't. It's not the video is not the fruit of the audio here. And I
don't know if
realize
this-
we're not
I don't-
talking about
Right, I don't know if the
constitutional law, but where the jury is going to have no knowledge whatsoever that anything was ever recorded, it seems perverted to say that we're exploiting.
But the statute says any, which means any, and it means we've identified the parties by visual means, and we've also shown there's an existence of a communication because his lips are moving.
True, but there's the entire. I mean, yes, granted, there's that language in the statute, and I'm not going to deny it, but to apply it in this situation, again, would be what this
I have
court
no
is-
problem if this was a constitutional usual suppression. I think you'd have much stronger grounds, but here I'm just trying to interpret the statute.
Right, and my position is that, the Commonwealth's position is that where you have no evidence of an intercepted recording, that the knowledge, the information regarding the identity of parties to this now non-existent, unknown interception of communications does not require suppression of the video, because of course, if you had two people separately doing it, you wouldn't suppress the video. If they had only done video and never done recording, of course, you wouldn't do the video.
What case are you relying on for the proposition that video is not suppressed?
Oh, well, the first thing I'm relying on is the statute itself, which says, of course, the statute itself says, of course, communications. And then, hold on a second, I'm going to have to check this, but I know I cite in my brief several cases that say video recordings are fine. They do not violate the wiretap statute. So the only question here is,
So
does the
that's in
worst...
your brief? You have a series of cases that in Massachusetts have held video doesn't violate
Yes.
the wiretap?
Silent video does not violate the wiretap statute. So even if it did show the defendant's lips moving, that's not an interception. It would be an interesting case if we brought in a lip reader. Then I think you'd come back into the realm of interception of communication.
Cases you rely on, you're relying right on Hyde and sort of dictum in those cases, right? You don't have any case that squarely holds that, right? That video is not covered, or is there?
There is. I can find it in just a second.
If that were the case, every traffic camera case you had, you couldn't introduce it. Every 7-Eleven video you couldn't
Right,
introduce.
of course, absolutely. We've seen these, silent, the cases in which there's a whole collection of surveillance cameras. But no, there's case law that explicitly said, and I cited in my brief, that explicitly says silent video. So the only question is whether this language, the identity of the parties to the communication, requires suppression in this case, regardless of whether the Commonwealth benefits in any way from
And it
that.
also says any information. It doesn't say any communication. It says any information.
No, it says any information regarding the identity of the parties to the communication.
You're
That's-
right.
Connects back to communication, but it connects back to the
Yes,
communication.
thank you.
But it's, when it's integrated, when it's the same thing, that the camera's on, we're all familiar with, this one we can talk to. The camera's on, the red light's on, it's recording, audio and video, right? Can we really separate out this?
Isn't there a mute button?
Oh, of course. I don't know.
So it's not, although it's taken at the same time simultaneously, it's not non-separable.
No, it's entirely separable. You can do it. The officers testified that he didn't know whether he could have muted it at the time, so there wouldn't have been any question of a wiretap violation. But you can certainly mute the tape now. That's easy.
But when he does it simultaneously, and we know there's an oral communication going on between the defendant and the police officer, and we also know there's a visual memorialization of that, can we really separate this out? It just seems like it fits right within the definition of contents then.
Well, no, contents are the actual contents of the communication. Transcripts are the classic example.
But that's not how it's defined.
That says identity.
But by case law, it's defined as anything that's derivative,
Yeah.
right? So you couldn't have someone listen to the illegal tape and then say, "Oh, I think this is what they said."
Yeah.
And you can't have a transcript of it. It's all derivative of it.
Right. And this is not, here the video is not derivative of the audio.
Yeah, I don't know if this unitary audio-visual has legal significance, but I'm just, again, as I keep, beating that dead horse, I'm stuck on the statute in the language.
Yeah, the
which
language
problematic for you,
is
Tim.
confusing because you are.
I don't think it's
the idea-
confusing, I think it's bad for you.
I prefer confusing, Your Honor. I see my time is up. Are there any further questions?
I have one, because I need to go back to the limiting principle here, because I'm still stuck on what Justice Gaziano asked you. So you keep saying that, assuming that there's an interception here. So you're seemingly arguing exactly what he said you are arguing, but you said you weren't. The visibility of the phone, and that the visibility of the phone, in your view, negates any notion of secrecy. And so, again, how would you limit that? I mean, how would you address a situation where a person is not paying attention and somebody just has their phone out? And how can you always interpret that the person is always potentially being recorded? What's the limiting principle to your world?
Well, certainly, if it's open, I mean, again, going back to my phone, certainly, if it's out in front of the person like this, or at a concert up like this, it's, the person is obviously recording, and that is clear. That's also the situation in the Counselor O'Neill case, where the recorder simply has a camcorder perched on his shoulder at a public event. And it's clear in that case, and this is why I talk about the actual knowledge standard, that the counselor was oblivious to the camera. But that's not a secret recording when you have it up on your shoulder, or you have it in those positions that I illustrated.
Is that inconsistent with your other argument? Your second argument, which is that video is completely severable, so maybe it's just a video that's going on.
I'm afraid I don't understand
You're
your
saying
concern.
it's, if the phone's out, you know you're recording,
Yeah.
right? But you're also saying in your other argument, the phone's out, it may be just doing video. I don't know. I just find that the two can't be separated out.
So you're going back to the second point, the video.
Yeah.
Yeah, I think it can, because you really, unless you interpret the language of the statute to an almost persnickety level, there's just no benefit here. There's no connection. Once you eliminate the evidence that there was an intercepted communication and you're left with the video is no different than it would be if it hadn't recorded sound in the first place. And to suppress them, to suppress the video in that circumstances will not be consistent with either the purpose of the wiretap statute or the purpose of the Fourth Amendment.
Can I ask one final question? Sorry. I'm just looking at 99P, and it says that the person who's been, subject of a wiretap violation may move to suppress the content of any intercepted communication or evidence derived therefrom. And it seems to me that or evidence derived therefrom counters your point about the video a bit, because it allows the suppression of the contents, which is a defined term, which Justice Gaziano took you through, but then it also has the ability to suppress the transcripts of the art of the somebody else hearing it, or I don't know, evidence that sort of fruit of the poisonous tree type kind of evidence. So your argument that contents can't possibly mean all the the fruit of the poisonous tree, it really sort of doesn't fit with the statute, which says you can suppress contents and the fruit of the poisonous tree.
But again, the fruit of the poisonous tree is something that you get from that. Like, if he said, the defendant said, "Oh yeah, I live on St. James Street," and you went back and you found, aha, there's a guy with his name who lives at 20 St. James Street. That's derivative evidence. That's fruit of the poisonous tree. You don't have that here. Here you have two things that are made simultaneously. Neither one depends on the other. It could be an audio recording without a video recording. It could be a video recording without an audio recording. Here it happens to be one and the same. But that doesn't mean you can't separate them out and say that the video does not violate the purpose of the statute. The audio does.
Okay, thank you.
Thank you very much, Your Honors.
Attorney Dolberg.
May it please the court, I'm Nancy Dahlberg on behalf of Thandu, and we are asking the court to suppress both the audio and video components of these unitary audio-video recordings. I'm happy to answer any questions about the audio. I will simply say, unless there are questions, that this case does not present any far-reaching issues regarding the audio. There was no, the court will have an opportunity, obviously, to look at the videos, but as the appeals court found, and I assume is the reason that the Commonwealth never raised this issue before Judge Hom, is that they don't show anything. They don't suggest anything about how the cell phone was displayed. And that was found by the appeals court who reviewed them, and I think it'll be clear to this court upon reviewing them that the issue here is nothing other than these were secretly made. There's no evidence to the contrary.
Can I ask you about your
yes.
statement that this is a unitary recording?
So
Why
this,
does that matter?
well, it matters because the video is accompanying the audio. So the way the Calio app works, at least in this case, according to the testimony, is that you can't, it is recording the audio and the video, and you can't turn off one or the other. So the police.
So you can't mute the audio?
Not when the recording's being made.
No,
I think
but
that-
when it's being played.
But when it's being played, I suppose you can always do that, and there are other problems that I can get to on the video for that. But, so this is a situation, and only a situation, where the video is accompanying the audio. And it was interesting to me to learn that the state police, when they promulgated their regulation concerning covert audio recordings, defined it as audio that was accompanying, the video that was accompanying audio. So that is how it works. They're together. They're not being recorded separately. They're not being recorded at separate times. And that goes to the definition, but I don't want to get too far ahead of myself.
2 phones on him, one recording audio and one recording video. How would that play out? It's the same event, but we often have these drug dealers with 2
Right.
phones, and cops with 2 phones. So how would that work? I'm just,
Well, it's a separate issue that's not addressed in this case. The problem, and I don't want to get too far ahead of myself if there are questions about the audio.
I think we're all very interested in the video.
The video. So the video, I would go back to the definition that has already been discussed. So, Mr. Du has the opportunity here to move for suppression of the contents, any information concerning the identity of the parties to the communications or the existence, contents, substance, purport,
Does that
or meaning.
modify the wire communication, though?
That would be oral or wire communications, all of which are implicated in this case.
Right.
They're all covered.
When we talk about oral and wire, we're talking about audio communications,
The
not,
audio, and in this case, the contents includes the video.
not if it says the contents of an oral
Oral or wire communications, and in this case,
wire communication. 'cause
recordings-
It's not oral, right? So you're saying the wire communications is the video portion?
no.
Okay.
The unitary recording
That's a
covers-
made-up term, the unitary recording.
Well,
That's not in the statute.
The
It's not-
appeals court, I think it's a very apt term. It's a recording made of audio and video at the same time in the same file.
And you're saying that that together constitutes an oral or wire communication as,
Yes, and I think as the appeals court described aptly, the original recording of the oral communication then became a wire communication in the subsequent recorded events. So,
But
do you think are you saying that that's what the legislature had in mind, that oral and wire communications encompasses both audio and video recordings?
well, what the legislature had in mind was the ability to suppress the contents. In this case, the contents includes the unitary audio-visual file.
I'm just having a little trouble with that because, as I think Justice Gaziano pointed out, the question is, what does contents, what's the modifier here? What does contents encompass? And you're saying, your argument is that it is the unitary audio and video
Yes.
recording.
So
but
that-
I'm not
and
sure
that-
I'm not sure what the basis for that is. Because
It's the
oral and
oral,
wire communications are audio.
oral and wire communications are both implicated in this recording.
Can you explain that? I'm sorry to interrupt, Chief.
No, I think that's what
So-
I'm trying to get.
Yes, so the,
So there is an oral communication between the undercover officer and the defendant.
yes, and it is part of this audio-visual file. They made,
There's an.
When they
okay.
correct- when
So
they-
there's an oral communication between the undercover officer and the defendant. And then, I'm sorry, what is the wire communication?
and it is recorded and transmitted, and the transmittal to the
But the
rest of the team.
communication between the officer and the defendant is not being made by means of a wire.
No, that is being recorded on,
That's separate.
The
There's
phone.
There's a recording between Officer 1 and Officer
Right.
2, right? Then that's consented to because they both know that that's happening. What I don't understand is how there's these, I think the appeals court calls it 4 interceptions or.
so the initial recording of the oral communications, which is accompanied with the video, is a secret interception of these communications made by Mr. Dew.
But Mr. Dew is not using any wire to talk to the undercover cop.
Right. It's being recorded,
Yes.
and then at the same time it's being transmitted to these other officers, and it's going
But,
to.
but Mr. Dew is not doing that.
No, but his communications are being intercepted by the police. It's
No,
a-
but for it to be a wire communication, his communication needs to be by means of the wire. And his is just oral, or speech.
So what the appeals court explained, and I think correctly, is that the oral communications are being recorded, Mr. Dew's oral communications are being recorded in violation of the statute because they were secret, and they were not pursuant to a warrant or an exception to the statute. The second step is when they are being transmitted to the other cell phones, that is a wire communication.
Is it? I guess
Well,
that's
yes,
my
I think under
question.
the
That's my
definition-
question. Yeah, like what, how is that, how
Definition-
does that fit with the definition? Is that a
A
communication?
wire communication includes transmissions made over cellular networks, as they describe, as the definition is made in part through the use of facilities for the transmission of communications by the aid of wire, cable, or other like connection between the point of origin and the point of reception.
Right, and
Which
the
has
point of
been
origin-
interpreted, in Moody, cellular calls are included.
That's not my point. My point is, Mr. Dew isn't communicating with anyone over a wire.
No, but the recording now of him is being sent far and wide.
That has to do with how many violations of the wiretap statute
Right,
there are.
but that's-
All you need is one.
Yes, so
Okay,
I agree.
but, so now let's
Okay.
get to the
Okay, so to
The-
the video.
video.
Video,
Yeah.
okay. So the suggestion, so this is all recorded, there's audio and video at the same time. His identity is clear on the video, the existence of the communications is clear on the video. What the Commonwealth would like to suggest is that the video be altered and presented at trial, because after all, the police officer is able to provide live testimony. So the suggestion is that this video would be presented to the jury, even though an interception, a violation of the law has occurred, right? So they would be presented to the jury as though there was no violation, even though it is evidence of the
So
violation.
hypothetically, if Mr. Dew said, that wasn't me, that was my brother, they got the wrong guy, they could play the video portion to identify him as the speaker, correct?
They could play the video portion and say, this is where I had a conversation with Mr. Dew, and this is what he said. So, of course, they benefit from the existence of the video. And, deterrence is an articulated goal of this statute, deterrence of interference with privacy rights of individuals by law enforcement. This is the fact that police in Boston and Worcester, I mentioned Worcester in
If
there
they
as
had,
well.
if they had video from a dash cam, no audio, that wouldn't be a problem at all, would it?
Not to my knowledge. But this
He
accompanies,
had two cell phones, one doing audio, one doing video. The video would come in.
as far as I know, this case is
You're
really
really
very
putting a
limited.
premium on the fact that they're being done simultaneously.
And that's,
They're being done, the audio is implicated, the video is implicated here because it's part of this,
thing.
I'm sorry, unitary file
That's
that's,
what file? Because,
Well,
you know,
so
does that work
it's-
technically that way? Because I think the video file would be separate from the audio file.
well,
my
so this is
understanding.
being done simultaneously on the same, with the same software on the same phone. So it's an audio-visual recording made at one time with one app that violates the rights of people who are being recorded.
Why
and
can't
the-
you take away the illegal part, the part where there's oral communication? Take that away, because that was illegal, and what you're left with is the visual part.
So I do want to go back to my deterrence point on that, but to go back, so what the court would be suggesting, or the Commonwealth has suggested, is you would take something, scrub out the part that was illegal, and then you would have the police officer using that to his benefit and saying, this is where we were having this conversation, and presenting it, excuse me, as something that was allowed when it wasn't. It was a violation of law. They're going to be
But that's the
presenting.
question presented. Is it a, you know, do you get, there was a violation, audio. Does the statute require the suppression of the video? And it seems
Yes,
like because it was made at the same time?
Because it shows it's evidence of a violation. It is evidence of a violation. If someone were to cross-examine the police officer and say, well, did you do this secretly?
supports-
Yes, I did it
supports the-
secretly.
It supports the oral stuff clearly meets all the definitions of the statute, and the video helps establish, provides further proof of the oral.
Exactly. And
And it's inseparable in the sense that it's good proof because it's not two separate phones or anything. It's the exact same thing.
Yes,
That's
and-
why the appeals court put so much emphasis on unitary.
But are we
Absolutely.
reading that into the statute, this inextricably intertwined or unitary? This doesn't appear in our case law or the statute, right?
I think the definitions are clear, Your Honor. You know, as we know, we've said many times, the statute's from 1968. But things have been updated, and at that time, we did not have these iPhones so you could carry around, and the police, you know, using in the way that they did here. I think the statute clearly encompasses this, but
You think in 1968 there wasn't audiovisual?
there wasn't the ability to walk around with
No,
an
but there
iPhone.
was audiovisual, so this unitary
Yes.
concept existed in 1968, right?
Right, but undercover police officers were not using this. They were using some kind of, right, they didn't have this ability. They didn't have,
They had monitoring devices called KELs. It's in the statute where they would just broadcast for officer safety,
Yeah,
but that was clearly
I do want to talk.
not preserved.
I'm sorry. I did want to talk about deterrence a little more before my time runs out, because it's clear from the testimony in this case, and as I say, this case in Worcester, where Judge Locanto recently granted a whole bunch of motions for a new trial, that the police have been using Calio with no thought to the statute. They have been recording people in violation of the statute, you know, quite a bit, widely. And if the court were to say, well, we're going to just scrub this, we're going to pretend there wasn't a violation, we're going to show this, you know, video, there's no reason for them to stop.
Well, how helpful is the video without the audio?
Oh, it would be very helpful.
So
Sure.
they could just start using the video portion,
Right,
right?
so
I
just
mean,
do
they
the
could just
video.
video the transaction.
They can, if they don't want to violate the law, that's an opportunity they can have, they can, yes, but
When we say that using the audio and visual unitary thing is not legal, I would hope that they would hear that and not do it. But if they do, they don't get to use the audio.
They also subject themselves to criminal liability.
Exactly.
well, you know, there is an exception in the statute if something, if this is done for officer safety, they're not going to be, it's subject to suppression, but not to liability. I would only say that in terms of the police recording audio and video, that's, the problem is the violation of the statute. Yes, if they stopped using Calio the way they're doing it, but one might have thought that that would have occurred prior to now. And certainly, yes, I would hope that the court would encourage compliance with the statute, which, you know, has a lot of important goals. So we would ask for suppression of both the audio and video in this case.